Good afternoon, everybody. Thank you so much for joining this month's industry update. I'm Jill Cox with Heritage Title. We're super excited to have a repeat guest, always super popular, Merc Pittinos. Merc is a real estate litigator. He deals with buyer and seller disputes. This is buyers and sellers sue each other and sometimes drag their brokers in the mix. And he's going to share with us today what are buyers and sellers suing each other about these days, and how can brokers protect themselves and hopefully not get to participate in that legislation. So I'm going to be monitoring chat and Q&A. If you have questions, please drop that in the Q&A and we will tackle those questions as we move along here. But with that, I'll turn everything over to you, Merc. Thanks again for your time today, and we can't wait to hear what you have to say.
Sounds great. Thank you guys both for having me. What I wanted to talk about today is just a little bit of background on how do you avoid litigation, and what are the biggest problems that we're seeing in the courts. The first, and before we get started, I just wanted to thank you, Jill, for everything that you do, and Damien, the work that you do to be able to benefit brokers in the real estate community. Colorado is unique in that we have we do billions of dollars of real estate transactions a year. Most of those, there are no problems. That's a testament to great title companies, testament to the professionalism of the brokers, and there are a lot of people like you, Damien, that help to increase the level of professionalism and quality of brokerage. And most transactions happen without any lawyers being involved.
Thank God, Merc, because you guys are a pain.
Oh, I know. That's
of course, you don't get to deal with the front stuff on the front end. You get to deal with it when everybody messes it up. So
what is good though is that unlike a lot of other states, lawyers don't have to be involved in the transactions. That means they move much more quickly, and then you've got pros handling them that don't slow them down and mess them up. So one of the first thing that I think is helpful just to emphasize for brokers of how do you stay out of litigation. The number one type of suit that we see over and over and over again are non-disclosure suits, where somebody moves into a house, they start doing some remodeling, they take off part of a wall, they see evidence of a prior leak, and they immediately think that the person that sold them the home lied on the disclosure form, and that person should pay to do what are $10 to $15 to $20 to $30,000 worth of repairs. And when we see non-disclosure cases, they fall into three different categories. One category of those is just because you found evidence of a problem, it doesn't mean that the person that sold you the home actually knew about it. There are a lot of times where there could have been a problem 1, 2, 3, 4 buyers beforehand, and especially if it's something that's under a rug or behind the wall. So it may be that the person that sold the home legitimately had no knowledge of what happened and didn't lie at all in the disclosure form. Then you have kind of the next category are really good people that say, you know what, I totally forgot about that thing that happened at the home. You're exactly right. I did the wrong thing on the non-disclosure form, and I'm going to pay you to be able to fix it. On the opposite extreme are people that fully lie on non-disclosure forms. And that does not happen particularly frequently, but when it does, it's usually really bad. It's somebody that will have done unpermitted work, they've done unpermitted electrical work, they will have built decks, put in doors, all kinds of things that violate code. And when you run into that type of problem, it tends to be really big and really bad and really expensive. That's one where it's helpful to have a lawyer. And then you have people that are kind of in the middle where they're not, they say, you know what, we don't want to pay, we didn't know anything about it, but there really wasn't any wrongdoing. So I think the takeaways there, sometimes one, as brokers, it's really helpful to you can't educate your clients enough on the importance of filling out the disclosure form and slowing that process down a little bit to say, look, this is really important. There are a lot of people think that if they disclose something that it's going to inhibit their ability to do a deal. My experience is that when you're selling a home and you find a buyer that's excited about it, they're less concerned about something that's disclosed than they are about something that's not disclosed, and it almost never blows up a deal. But from the seller's perspective, they think anything they write is going to blow up the deal and either impact the price or slow down the sale. It's especially important to be able to say, look, that can happen, but it's way more important for you to be able to over disclose than under disclose. And especially with the speed that real estate deals happen, it's important to slow down and take a lot of time to fill out the form.
Yeah, along those lines, Merc, I always tell people if the buyer's going to walk away because of something you disclosed in the seller's property disclosure, it's probably a good thing that we disclosed it, because that's the person that was going to sue you for it anyways.
That's exactly right. That's great advice. I have a similar story that I tell people all the time, is that sometimes when people back out of a deal, that's the number one deal that you want to get out of, because those people that back out are also the people that are the ones that are going to end up suing you. So sometimes you get into an earnest money dispute and somebody's trying to get out of a deal. You look at it and go, this may be a blessing in disguise, because you can't control who you're doing deals with. And if somebody is aggressive and antagonistic and they're that way at the beginning of your relationship, they're going to be even worse later on.
Yeah, I think that's good advice.
Hey,
I had a question for you. I don't know if you were going to cover this or not, but you talked about one of those categories being the seller does want to pay. So can you talk a little bit about how that looks, what that looks like when the seller says, you're right, I did make a mistake, I want to give you some money to fix this? I mean, do you get involved in those, or what do you see in those instances?
Sometimes I see two different things. The first is that, especially if you have a good relationship with the seller and the buyer discovers that there's a problem. I've seen it a lot where lawyers aren't really even involved at all, and the buyer reaches out to the seller and says, this problem came up, this wasn't disclosed, we think you knew about it, here's how much it's going to cost. So that's one piece, is that you need an invoice or documentation to be able to establish what it is that you want, and then it gets resolved. Sometimes it takes a little bit more pressure, and what you need is a letter from a lawyer to the seller saying, here's the problem, here's how much it's going to cost to fix, and if you don't fix it within, or send a check within X number of days, we're going to file a lawsuit. That kind of letter to send it costs, depending on how complex the problems are, $500 to $1,000. So a lot of problems, if it's $10,000 to $15,000 to fix, my advice to people is it's really not worth getting a lawyer involved, because you don't want to spend a bunch of money on a lawyer letter that's going to achieve nothing. But if someone's non-responsive and you have a problem that's $10,000 or $15,000 or $20,000 to fix, a good solution is a letter from a lawyer to help push things over the edge. For the type of person that especially as you get to know someone through the course of a transaction, if they're the type of person that is not going to pay and just denies that there was ever a problem, those are also people that I recommend. It's really not worth sending a letter, because you know what their reaction is going to be. And at that point, you really have one of two choices: either sue them or walk away, fix the problem, and get the problem out of your life. And the place to me where it makes sense to sue is when the problems are really expensive. And the way that when I'm working with people to figure out, do you file a lawsuit or not? To me, it's totally a business decision on whether you spend the money to be involved in litigation. And the threshold is, depending on, $50,000, $75,000, $100,000 problem is one where you start to think about litigation. But really, for it to make sense, there needs to be a significant upside in what you spend in legal fees. And you really want to look at something where you're at 5, 10, 20x on what you put into legal fees, because a lawsuit is so time consuming and stressful that if you recover what you spend, or you recover slightly more, even if you recover double, at the end of it, you'll look back and say, I shouldn't have gone down that path. If you can take the money you spend and turn it into a 5, 10, 20x return, then it really makes sense. And that depends a lot on the people on the other side. It also depends on how clear the evidence is. And in non-disclosure cases, what you need before I advise someone to file a suit in a non-disclosure case, the evidence to me needs to be black and white. Because the example that we started out with, where the problem could have been caused and realized by someone 3, 4, 5 buyers and or owners before you, that happens all the time. And so what you're looking for is a neighbor or a contractor that says, I came into this house during the time that the prior owner owned it, and I saw this problem. And so you either need pictures of the problem, or you need a person that can definitively say, this person knew, and here is the invoice or the picture or the date that the problem happened. And if you have something that's black and white, then you go, okay, let's file a suit. Otherwise, what happens is a he said, she said type of suit. Those are really expensive. They almost always don't settle, and they're very difficult to win. So
what about the contractor that says there's no way they didn't know about this because of X, Y, and Z? Is that good enough, or is that starting to get to the line where they really got to think about whether they want to follow through with this?
That, I think, is still that's not, in my mind, that's not enough, because that person could say there's no way that they didn't know. You need somebody that can definitively, you need either a picture or a document or a person that says, this person told me X, or I saw X, or here's a photograph. Otherwise, if you go into court and you have someone that testifies and says there's no way that that person should have known, they'll figure out some way to work around it, and it still becomes a he said, she said. And that's why I always say it needs to be black and white. And if it's not black and white, you need to think long and hard about whether you're bringing the suit or not. And an example of that, I had one case where there was a mold issue, and there were pictures of different colors of carpet, and there were pictures of there was one carpet pad that was orange, and then a new carpet pad that was blue. And so you could see where the carpet pad had been cut out. There was video of water coming into the house, and there were definitive pictures where you could say it looked like this on one day and looked like something else on a totally different day. And you could prove what days those were to be able to establish knowledge. So that's what you really need, is either a letter or an invoice or a person that can definitively say, this thing happened on this particular date, and you know that going into court that you're going to win. If it's individuals telling different stories and a he said, she said type of situation, it's probably not worth it.
Okay. Can I ask a couple other questions, since we're talking about this disclosure thing? Because these things come up all the time in my practice, which then I refer them to you. But I think it's helpful for brokers to hear, how do you feel about like small claims action? So if it's not the 5, 10, 20x problem, how do you feel about sellers or about buyers going to small claims court and a process of dealing with that?
I think if the evidence is the same, if you have black and white evidence and the claim is in that $5,000 to $10,000 range, going to small claims court is great, because it's a simple and inexpensive way to be able to resolve a problem. And you don't have to have a lawyer involved. You can talk to a lawyer, get some advice on how to put your case together. But that's also a really good way to resolve it. But small claims court is not any different than going to county court or district court. If you have black and white evidence, most likely you're going to win. If you had a he said, she said story, it's going to be really difficult to prove the case and hard to win. So you need to think about the cases in the same way. But the benefit of small claims court is that you can achieve the same result with a lot less expense.
Okay, and then
There was a,
Oh,
oh,
go
sorry,
ahead.
go ahead. There was a question, is there a statute of limitations on claims like this?
So there are statute of limitations on this type of claim. The statute of limitations is there are two that can apply, but for the most part, it's a 3-year statute of limitations for a contract claim. There's some other situations where it would be 2 years, and that statute of limitations runs from the date that the claim accrued, and the claim accrues on the date that you knew or should have known about a problem. So what I mean, the reason that that's important is that if the problem is something that's behind a wall and you don't discover it until a year after you move into the house, because you took off sheetrock and then saw something behind the wall, and that claim would accrue on the date that you first saw the problem. So it might be a year or 2 years after you bought the house, and then you have 2 to 3 years to be able to bring the claim, depending on what type of claim it is. And a lot of people, that brings up another point. A lot of people think right away that the person that they should sue is the inspector for not discovering those problems. And most of the contracts with inspectors have caps on damages, so that the amount of damages that you can recover from an inspector is either $500 or $1,000, or it's capped at the amount that you paid the inspector. And that surprises people frequently. And there are ways that you can work around that with either a higher level of inspection or a higher cost. But those are things that are really good to be able to talk through with your clients, because if there is a problem and then they discover later on that their damages are capped and they can't sue the inspector, then they look to the broker.
Well, and then the other issue is that obviously the inspector can't see through walls anyway, so they're not going to be held to a standard that they should have been able to discover that there was a water leak behind the wall that there was no evidence of. So that also creates problems even with the cap.
Yep.
I had another question for you too that I'd like you to opine on, because I see a lot of buyers that feel like, oh, I'm going to get vindicated and then I'm going to get my attorney fees back because of the attorney fee shifting provision in the contract. Could you talk a little bit about what courts do with attorney fee shifting provisions and how it's not always black and white as to what they're going to get?
Sure. So that's there are two different answers to that. The first answer is that even if you file a lawsuit, 95% of most cases end up settling, and most non-disclosure cases that I've been involved in end up settling. Almost always they end up settling for less than the amount that it costs to fix the problem, and they almost never include attorney fees, even though there's a fee shifting provision in the contract. So that is my general experience, is that most of the time at the end, even at the end of a lawsuit, people are, and even if you reach a settlement, that's one of the reasons that it's a lot of people will finish the litigation or the dispute and say, you know what, I never should have started this process, because it's so unfulfilling both financially and takes such a toll emotionally. The other piece is that if you go through a trial and and you win, and we'll come back to if you win, then the court can award the reasonable amount of attorney fees. And the reasonable amount, I have seen everything from $1 being awarded to 95 to 100%, and all kinds of things in between. A lot of suits will have multiple claims, and so if you're totally the prevailing party, most likely what I would say to people, if you win, you should expect to win 65 to 85 to 90% of your fees, but almost never do you recover 100% of your fees. Another reason for not jumping into a lawsuit that's a he said, she said type of suit is that if you lose, the other side will recover their fees. And that becomes the ultimate nightmare for people, that you buy a house that has a problem. It's really expensive to fix. You file a lawsuit to be able to recover money and then end up losing. Then you have to pay the other side's attorney fees. And that's really where an ounce of prevention on the front end can really be a huge savings on the back end, and why people need to, as soon as there's a problem, people's immediate reaction is, I need to go sue somebody and talk to a lawyer. And that almost never works out the way that people hope. It's my wife's favorite thing to say. It's like, nobody gets justice.
I like to say nobody wins but the lawyers, Merc, but you know.
That's not always true either.
Yeah, true.
That's not what the lawyers think when the judge knocks their fees down 30 or 40%.
Yeah.
But it's a really good point, that when somebody's really mad is not the time to decide whether you're going to sue somebody. You really look at it as in some ways it's not that different than gambling. And you go, okay, if I can get a 20x multiple, it's worth making the bet. If I am making a 50-50 bet, it's probably not worth it.
So let me ask you this, and I know that we're treading into one of your topics about unauthorized practice of law, but you got a broker that has a buyer that comes back a month after closing. I get this call all the time. Buyer says, I found out something that I know the seller knew, may not be black and white like you're talking about. Can you kind of walk through how a buyer broker should be advising their client, and obviously you got to be careful here about the legal advice, but they want to help their client, but I don't know how to. I always tell them that they got to be real careful because they can't give too much legal advice, but at the same time, setting some of those expectations might be helpful so that they're not thinking that they're just going to go sue some seller and get and be made 100% whole.
So I had two reactions to that. There's advice that to be giving on the front end of a deal, and then advice on the back end. And to me, what I like to tell people is that if you start to type in additional provisions, that's when you go, okay, hold on. Do I really want to be doing this? And if it's something simple, probably not that big of a deal. If it is an option or a right of first refusal or a right of first offer, 100% stop typing and tell them to go talk to a lawyer. If it's tying a purchase price to an appraisal or anything that is giving somebody a right that's not already spelled out in the contract, that's a time where you need to stop. There's things that are simple, like you're going to pay $125 to fix something, not a big deal. But when you start typing something that you've never done before, that's when you need to stop. Even when I'm talking with any type of broker, commercial broker, residential broker, this happens more in the commercial context than in the residential. But even real estate lawyers are not good at drafting right of first offer, right of first refusal, and options. So even when I'm looking at leases and contracts that are drafted by really good lawyers that may not spend all of their time on real estate, those provisions can be messed up really badly. And if they come from a form off the internet, they're almost always wrong. And when those types of provisions, especially options that just get thrown in at the last part of a deal, when those are drafted, even when they're drafted by really good lawyers, they turn into massive lawsuits and can be monumentally expensive. And 10 or 15 words that really should be 50 or 100 or 200 can result in tens of thousands, if not hundreds of thousands of dollars of legal fees. So that's why we start typing in additional provisions be super careful. On
Yeah.
the back end, when there is a problem, the most important thing for brokers is, whether it's front end or back end, is don't give legal advice. You can say, look, this is really complicated and there's a problem, but before you make any moves, I recommend that you talk to a lawyer and get some feedback.
Yeah, but Merc, they don't do that. I mean, it's like, yeah, but you're my broker. Just give me your opinion. Tell me what you think about this. And I wanted to comment real quickly on your additional provisions, because I agree with you. If nothing else, brokers, talk to your employing broker and get some advice. Find out, is this the complicated version, or is this the simple thing that we can put in? And they can give you advice as to where you need to go from there. Is it a clause that needs the client's lawyer to prepare it? Is it something that maybe your counsel for your brokerage firm has prepared, or something along those lines as well? But we do get but broker, you were representing me in this transaction, and I want to know what you think. Do you think they could go so far as to maybe say, look, litigation is complicated, there's all sorts of legal claims here, you got to ask yourself if it's really worth it first, because it could be, or do you want them just to send them to you to begin with, and then you can ferret out which ones to litigate or which ones not to?
I think so. One of the tensions of being a broker after a deal closes is that people, and especially when you start dealing with a problem and lawyer comes up, people know that it's going to be really expensive to hire a lawyer, and so there's going to be pressure to go to someone for free advice on what I should do, and there's double pressure because the broker has just received compensation for the sale, and so the person, the buyer or seller, then is looking for even more free advice to go, okay, who will talk to me for free? And then they'll say, you just made a ton of money on this deal, I need you to help me out. And saying litigation is expensive and complicated and it's almost never black and white, follow that up with, and I really think you ought to be talking to a lawyer, and put that in an email to the person to be able to say, look, I'm outside my area of expertise. I can help you do a deal, but I can't help you with a legal problem. Here are the names of a handful of people that I think you ought to talk to. And you treat that in the same way that you would treat a broken sewer line, or an electrical problem in a house, or a fence that needs to be repaired. Brokers don't fix those problems. They say, here, a handful of people to go and talk to. And that's my same advice on legal problems.
Great, thank you.
Merc, there was a question
oh.
that came up. If the buyers and sellers agree on a resolution to the problem without an attorney after closing, should there be a written agreement done between them that shows they agreed to the resolution? If so, who should or can write that agreement, and what is the best practice for this?
So there are a couple of different answers to that. One is it's really helpful to have a written agreement on that says what each person's going to do. I can just give you my how I deal with that. Sometimes we send a demand letter to somebody, and the person ends up writing a check, and that's the end of it. And there's not a formal agreement. But mostly what ends up defining whether there's a written agreement and what it says is defined by the amount of the problem. And on the seller side, that the seller, especially if the seller has to pay a significant amount of money to resolve a problem, what the seller will say is, look, I'm going to write a check for this amount, but I don't want you coming back for anything ever again. And this is going to be it between us. You're giving up any claims that you have from forever related to the property, and we're done. That's not something that would happen with a $1,000 or $2,000 problem, but it's a $50,000 or $100,000 problem that it would. So usually that just it's always better to have something in writing. It's really helpful because then you can pass that on to the next buyer of the property and say, look, here was the problem, here was our resolution, here's what I did to be able to fix it. But sometimes on a low dollar issue, it's not worth it. And there's nothing magical about it. On a more complicated agreement where you want a release of claims, then you want a lawyer involved. That's not something that you would want to do. If it was something simple where you said, I'm going to be paying X and that here's when I'm going to be paying it, that's something that people could do between themselves. Okay, the next question. Love when agents write earnest money shall be hard. What's the legal definition of
Of hard? It means
that?
you use it to pound nails.
So that should be written. Earnest money is non-refundable, and that this gets really tricky in a couple of different instances. One, usually when that kind of provision is written in a contract, there are other contractual provisions that that conflict with it. So even something that's simple like that, where you go, okay, earnest money is going to be non-refundable. On a larger dollar earnest money deposit, where it's $50 or $100 or $200,000, that's the sort of thing that turns into a lawsuit, because then somebody goes, well, hold on, is it non-refundable when you lie it on the disclosure form? Is it non-refundable when I terminate? And so you have to be able to take that language and then tie it into the rest of the contract and define exactly what that means. So that's one, you want to be really clear what it means. And then second, especially in deals where there's a larger amount of earnest money and it's something that someone would want to fight over, they will figure out ways to be able to say non-refundable means something totally different in the situation that I'm dealing with. And the example would be like on a commercial property, somebody will come up with an excuse about environmental issues to be able to say, yep, I've signed 1 or 2 or 3 agreements saying that the earnest money was hard, non-refundable, but I didn't know about this environmental problem, and so I'm going to rely on a totally different part of the contract to try and get you to give me my money back. When what really is going on is that interest rates changed and somebody's trying to use an excuse to be able to unwind parts of the contract. So the more dialed you have an additional provision section to be able to tie what you're talking about into the rest of the contract, the more likely it is that your client's able to keep their money when somebody tries to get out of a non-refundable provision. Cold cash or non-refundable?
I don't know what cold cash means. I've seen those several times, but back to the settlement agreement, Merc. You know, I do see where brokers will say, you know, the buyer says, I'm upset. Can you just ask the seller if they'd be willing to pay for this? So they'll convey over the message to the other broker, and the broker will convey it to the seller. And then the seller might come back and say, oh, fine, we'll pay something. But at that point, it's like, you guys are done. You can't do the settlement agreement or anything else. They want a settlement agreement, they're going to have to hire a lawyer. So, I mean, do you agree?
100%.
So, but
and
yeah,
I help people out a lot where that's really the scope of what I'm doing, is just helping draft a settlement agreement. And it's not super expensive, because that's something that lawyers do day in and day out. Most lawyers have a form that they can use, so you can do it relatively inexpensively. On a $3,000 settlement, it may not make sense to pay another $3,000 for a settlement agreement. But if it's a $50,000 or $100,000 settlement agreement, it's absolutely worth it. The other place where I see this happening a lot is I've had a couple of recent suits where, and we'll talk about deeds a little bit, because one of the things that people don't expect, not as much anymore, but in the last couple of years, when there were massive amounts of real estate transactions where homes were going way above asking price, What people would do to protect themselves is say, I'm selling you the home as is, whereas it would be written into the contract. But that language doesn't, never appears in the deed. And what ends up happening is that when you, what is written in the contract merges, doesn't merge into the deed. So the as is, whereas provision that's in the contract isn't binding after the closing. And that shocks people. So that if you're doing a deal like that and somebody is selling it as is, where is, but there's a title problem after the fact, that as is clause can't be enforced unless it's made part of the deed. That's the sort of situation where it is really helpful to be able to have a lawyer involved, so that if you're saying we're selling it as is, whereas, and you mean that we're selling it as is, whereas, with the sewer line and the property that's underground that nobody knows about, that doesn't really work unless you have something in the deed that says the same thing. That's an area that totally gets outside of the expertise of a broker or title company, and where you need to have a lawyer involved.
Yeah, usually they put that language in because they think that's going to keep them from being beat up on inspection, Merc. So, which most of the people on this call already know how I feel about as is, where is, but that's beside the point.
I've just had it come up in off-record title issues, and people go, "Well, hold on, we sold this as is, where is. We all agreed about it. Why am I getting sued for something later on?"
Yeah, you want to talk about that because there is a hole between the general warranty deed and the special warranty deed. I know you and I have discussed it before, even though they tried to fix a lot of that with the statute several years ago, but there is still a small problem. Maybe, I don't know if they know what you're talking about, so maybe.
No, so I'll with deeds that now say that a general warranty deed that says that has a reference to the statutory exceptions. What that means is that when you sign a warranty deed, it's really not any different than a warranty on anything else that you buy, a television, a car. What you're saying is, I'm warranting the title to the property, and that's why you have title insurance. But there's one carve out in with the statutory exceptions for off-record matters. And where I see that come up the most is underground sewer lines and underground electrical lines, things that are on the property that you can't see. And this is one of those times where maybe one of the best pieces of advice from today. It comes back to the issue on disclosures. One of the best things that you can say to a seller is, I want you to think about, is there anything that has come up that either that you wouldn't be able to see on the property? And does your neighbor have a sewer line coming across your property? Is there a fence line or an underground, any kind of underground utility line that goes across your property that you wouldn't be able to see? And have them put that on the disclosure form so that the other person knows about it. There are neighborhoods that were developed in the 50s and 60s that have sewer lines that on most homes, what you expect is that the sewer line goes straight from the home to the street. But there are some developments, and this happens all around the country, where because of the topography, it made more sense to be able to run a sewer line across somebody else's property. And when there's a rapid development happening and a developer owns all the properties, they would just put in sewer lines across neighboring properties, and they could be really long sewer lines. Those are incredibly expensive problems to fix. So what you want to do is say, is there anything funky on your property that you might have only had one or two conversations about during the entire time you owned the property that could be an issue for somebody buying your home? And it's not just, is it an issue for someone buying your home, but is it an issue if someone were to buy your home, take it completely down and build a new home? So that's where I've seen this problem come up a lot, because when those type of sewer lines were put in, they were put in for the footprint of the home that was there at the time. But with the type of redevelopment that's happening in Denver, old, smaller homes that are 40, 50, 60, 70 years old are taken down all the time to be rebuilt. And then someone's in a position where they're rebuilding a home on top of a sewer line and it becomes a massive problem. So especially in areas where there's a lot of redevelopment and homes are taken down and rebuilt, you want to be thinking about what's there that could impact the long-term viability of development of a parcel.
Now that makes sense, because that is the one hole in our special warranty deed versus general warranty deed that people don't realize still exists. So that's good, particularly in old Denver or some area like that.
Yep. And those problems can be really expensive to fix, because if a sewer line crosses somebody else's property, the warranty and the warranty deed protects the buyer. And in a special warranty deed, you probably wouldn't have any liability unless you knew about the sewer line being put in. But the difference between a general and a special warranty deed is that the warranty goes back in time, and you have to provide a warranty for title issues that were created long before you owned the property. So you could have bought a property in 2020, sold it in 2024, and you're responsible for the removal and replacement of a sewer line that was installed in the 1950s. It doesn't feel fair, but that's how general warranty deeds work. So that's why it's important at the outset to say, hang on just a second. Is there anything funky about your property that we need to make sure that we put onto a disclosure form?
Mark, someone just asked, what about title OEC coverage? You want to talk about how title steps in or doesn't step in those kinds of cases?
Yeah. So those the way that title insurance could step in is, so you have extended coverage. The extended coverage protects the buyer, but it doesn't protect the seller. So if the title company ends up paying out on the claim for the buyer, they can take an assignment of claim from the buyer and then sue the seller to be able to recover what they paid out. So that's why it's so important, is that buyers can end up being in suits with title companies to be able to recover what the title companies are paid out. What that is, that reminds me of something else that's really important for sellers. When somebody sells their home, they think, you know what, I can get rid of all these pieces of paper related to my house, and the title policy from when I bought the house 30 years ago. Now that I'm moving, I can clean out all these file cabinets and throw out the policy. And so that would be another great piece of advice for people when you're representing a seller. Don't throw out your title policy ever, because that sort of situation that I was describing, one of the questions is, how's the seller covered? Seller's covered under the policy from when the seller purchased the property. So if you had purchased the property in 1990, you sell it in 2024, and you get sued by the title company that had to pay out a claim, seller still has protection under its title policy, but you're only protected if you still have a copy of it, and you can give that to your title company. So title policies, don't throw them out.
That's a great advice, Merc. I hadn't thought about that one, but you're right. That's where the coverage would come. And then OEC might cover survey matters or fences, but it wouldn't cover your underlying sewer line anyways.
It could, but so one of these questions is, does disclosing the funky sewer line really absolve you of the future liability? Yes and no. But that's one of the number one. If you're telling somebody about the funky sewer line, it becomes impossible for them to be able to come back and say, I didn't have knowledge of this. And that puts you in a much better position for avoiding a lawsuit than a situation that you didn't have any knowledge of. Let's see. What happens if the title company is out of business or acquired? If it's out of business, they're out of business. But most title companies, it takes a little bit of work, but there are websites that you can go to that will tell you that this title company was purchased by this title company, which was purchased by Fidelity or First American or whoever it is. So most of the time it's pretty easy to figure out where you can make the claim.
And we're talking about underwriters too. We're not talking about the closing company. And, when we're talking about the title companies, guys, what we're talking about is the underwriter that insures the property, and they're typically
They're not going in and out of business all the time.
yeah, exactly. They typically have lots of money, and they might be bought out by somebody else, but it's not like they just go out of business.
No, that's exactly right. And that's what ends up happening is that sometimes with a smaller title company, they've sold or they've gone out of business, but the underwriter that actually gave that provided the insurance, I've never had a situation where we couldn't find the title insurance company. Okay, then there's a question about internet fiber optic lines.
Internet fiber optic lines.
I'll read this so just in case people are listening and not reading the Q&A. So Longmont's next slide, internet fiber optic lines run across properties all over town. Assuming this could be an issue similar, since multiple properties would be affected by a cut in the line somewhere that has to be located to get service back to all in that line segment. So
Yeah,
like a sewer line.
A lot of that depends on whether or not it's actually in an easement, though, guys. If it's because the fiber optics lines, Mark, correct me if I'm wrong, but I believe there was a bill that passed several years ago that extended like the electric utility or the utility easements to fiber optics and internet services so that they can now use those for them. What Mark's talking about is when there isn't a recorded easement for a utility or something on the property that the seller may or may not know about, that creates this hole in the deed. If there's an easement already there, there's an easement already there.
That's and a lot of times that's exactly really what I was talking about. It's slightly different. So one is call before you dig, and then you won't have neighbors that are irate because your contractor shut down internet to the whole neighborhood. But really and this doesn't happen as much anymore, it's really in neighborhoods that were developed in the 20s, 30s, 40s, 50s, and 60s, where there was less oversight by municipalities and developers would just do whatever they wanted. And if it was less expensive to run a sewer line or a utility line across somebody else's property, they wowould do that. And there would be no recorded easement to be able to reflect it. So it's if this is not something that would come up in a new development on the outskirts of Denver or in newer municipalities, it's really something that would most likely have happened in the 40s, 50s, or 60s.
There was a question mark going back to the as is discussion. So what about as is on a PR's deed? Personal representative's deed.
So what's most important is that it's written on the deed, and when it's written on the deed, then you don't have the issue that we were talking about, where the language of a contract, unless it's written on the deed, it doesn't make it in there.
Now, the one thing though with a PR deed, though, guys, is that a PR deed is essentially a bargain and sale deed. It is not a warranty deed. It's not a special, or at least I've never seen one, Merc. Have you seen where they've done a PR deed as a special warranty deed?
No,
I usually see them as bargain and sale deeds, which means that there aren't those warranties anyway. So you're not going to have the issue that Merc's talking about suing through on the warranties under the deed. But also, if you have language in there and it's very important to your seller to make sure that they're not going to be sued for as is, then the seller needs to hire a lawyer to make sure that they're crafting the deed to be the way that they want it to make sure they're getting that full protection.
That's a great point. Okay, this is a question about title insurance and interfamily transfers. So the question is, okay, you have a property, it's in a trust, it's passed to children. What do you do with the title policy there? And this is a really important issue for this could relate to trusts, it could relate to LLCs. So if you take a property that's family owned, you put it in an LLC, and somebody's children are the members of the LLC. Anytime that you have a transfer, even if it's an interfamily transfer, what you want to do is go back to the title insurance company and ask them for an endorsement on the policy, so that the people that own the property and hold title to the property are the ones that are insured. So a lot of times someone will own a property, they say, okay, I'm gonna move to another house, but I'm gonna turn this house into a rental property and put it into an LLC. When you make that transfer, it's really important to also to make sure that the title insurance policy is changed so that the LLC is insured. It's not it's not very expensive. It's really easy to do. And a lot of lawyers that are trust and estates lawyers will sometimes forget to do that. So when you go to a trust and estates lawyer and you're thinking about transfers for liability protection or tax purposes, they're really good at thinking about how to do the tax part of it, but not as good on the real estate side of it. So that's important to remind people that any kind of transfer should be dealt with an endorsement, because that's a really easy way, if you have a title claim, for a title insurance company to deny, because the person that holds title of the property isn't the person that's on the insurance policy.
I think that's all the questions for now. Do you have anything else for us?
The only other thing that I like to, that I like to remind brokers is just that you're the eyes and the ears of your clients. And when I think there are actually two things that I wanted to say. The first is just that you're the eyes and ears for your clients, and as in the same way that a lawyer or investment broker, you're dispassionate about the deal. And when people are buying a home, they get so swept up in the motion of the purchase that they don't see things that they normally would look out for. And that's one of the most valuable services that, as a broker, that you can provide to your clients, is that usually is looking out for the things that seem just a little bit off. Sometimes that's a candle burning and open windows. Sometimes it's something funky in a fence. Sometimes it's a smell. But I see it all the time that disputes come up and people go, you know what, when we were walking through that home, something just seemed out of place. I was so swept up in the deal and visualizing myself in the home that I ignored something that turned out to be a huge deal. And as a dispassionate advisor to clients, the things that you see, that because you see so many homes and you're in and out of homes, the things that just whatever it is that seems a little bit off, trust your gut on those things and dig a little bit deeper and advise your clients to be able to get help on those things. Because those are, I've seen it over and over again, where someone says something like, oh, it was a little bit weird. We went into that house and there was an open window in the basement. And then when we moved in, there was this smell that we didn't smell. And then that turned out to be something much bigger. So keeping your eyes out for things that are out of place and unusual can help you save your clients tons and tons of money and help avoid problems and keep them as clients for life. The second thing that I think that's really important is that in a down market like we have right now, when there are not a lot of transactions and deals are really hard to come by, don't change the way that you act with clients, because even though you may not have had a deal in a while, and you go, okay, this is got to feed my family, and I need to. I don't see what the next deal is. The two pieces of advice that I have there are: don't get outside of your lane and start working in geographical areas or market sectors where you don't have expertise. I see residential brokers go, okay, now's the time that I need to get into commercial brokerage. I see a residential brokerage where they say, okay, I have Longmont dialed, and then because there's a possibility of a deal in Denver, they take that on. So don't change what you do geographically or market segment wise just because the market's down, because that's when that's when problems get created and big mistakes are made. And so those are the two, to me, are the two most important things. Be your eyes and ears, and don't get outside of your lane.
Now there's one other, Merc.
What's that? Always
Put it in writing.
put it in writing. That's true. Put it in writing, and always, this wasn't such a big, I meet people all the time that go, thank heavens I'm not in college now, because everything is recorded. But that's one thing. There's a Ring camera on every front door. Anything that you say when I am getting ready for Dave's presentation, I look at this and go, all right, everything that I'm saying could be used against me in a lawsuit. And you guys need to think the exact same way. Everything that you put in writing, everything that you say in a phone call, everything that you say in a voice message, everything that's in a text or in an email, expect that it's going to be shown on a screen in front of a judge in a courtroom. And if you do that, you're going to be covered. And if you
Do it
even
right.
in the rush of a deal, everything that you write is can get you in trouble.
Yeah, do it right, because you don't want to write the thing that says this guy is a jackwagon. That's not going to help you in court.
Don't call and leave somebody a message or tell them that your clients are old and having trouble making decisions, or you go. Never say anything bad about your clients, and never put anything in writing that you don't want a judge to
read. I think that's all good advice. And I think Merc just gave you guys some value propositions in case you were wondering if you needed some more after last week's industry update. But yeah, that's important information. And I did not pay him to say that, in case you guys were wondering. So
one last question, then I think we're running out of time. If someone's refinanced and essentially gotten a new title policy, will it supersede the general one when they bought the house? Okay, so that's when you buy a property with a loan, there are two different title policies that are in effect. One title policy is to protect the owner of the property, and then there's a second policy to be able to protect the lender. And so when the lender refinances, that's up to them to be able to have a new policy in place to be able to protect the lender. As long as there's no transfer in the title of the owner, there's not anything that you need to do. But a lot of times when there's a refinancing that happens, there'll be a quitclaim deed that's done where somebody's middle initial needs to be added, or somebody's being added to the property to be able to provide support for the loan. Any kind of change like that, you'd want to go and have the title company issue an endorsement so that the name on the deed matches the title policy.
And don't get rid of the original one, is what I heard you say.
Yeah, don't throw those out. And luckily, a lot of them are sent by email, but don't delete them, and keep them forever. That's
Great advice. Okay. I don't see any other questions. Oh, let's see. One just popped in. Thanks for all the great information. Who can I sue if I'm awake all night due to nightmares after these classes?
You know what? The message there is 99% of the deals that are done, there are never any problems. And the best thing that you can do, Damien just said, if you do the right thing, that is the best way to be able to avoid a lawsuit or a problem. Do the right thing every time.
And let's see, we did record today's webinar just like we always do. So I'll send out a link to the recording once we have that uploaded to YouTube. And I'll also make sure to provide Merc's contact information. So if you do have a buyer or seller who says, I want to talk to a lawyer, he's your guy. So thank you so much, Merc, for your time today and your expertise. You always have such great information to share, and share it in such a great, clear, understandable way. So thank you so much for being a guest multiple times with our industry update.
Thank you for having me. It's great to be here today.
All right. Thanks everybody for joining, and we will see you next month.
Sounds good. Bye-bye.
Bye.